big surprise.
The U.S. Supreme Court ruled against lower courts issuing nationwide injunctions.
A federal judge just lost the power to control what happens in your state, and 47 other cases are about to explode because of what the Supreme Court did at midnight last night. The 6-3 emergency ruling that dropped while most Americans were sleeping has state attorneys general scrambling, federal agencies in chaos, and corporate lawyers billing overtime as they figure out what just happened to the American legal system. For the past 20 years, a single judge sitting in San Francisco or Seattle could freeze a Texas law. A judge in Texas could block California regulations. One person with a gavel could override the decisions of 50 state legislatures with the stroke of a pen. The Supreme Court just ended that practice, and the consequences are already rippling through every level of government. The emergency ruling came down late last night, catching even seasoned court watchers off guard. The conservative majority delivered a decisive blow to what's known as nationwide injunctions, those sweeping court orders that freeze laws across all 50 states even when only a few people sued. Justice Gorsuch's opinion didn't mince words, essentially telling lower court judges they've been exceeding their constitutional authority for decades. Within 3 hours of the decision, 12 state attorneys general filed emergency motions. Texas immediately cited it in 3 immigration cases. Florida brought it up in election law disputes. Arizona used it for border security litigation. The speed tells you everything. Legal teams across the country had been waiting for this shoe to drop, and now they're racing to take advantage. But here's where it gets really interesting. The constitutional reasoning goes deeper than anyone expected. Justice Gorsuch dug into historical records from 1789 to 1850, finding 12 separate cases where early American judges explicitly refused to issue broad injunctions affecting people who weren't part of the lawsuit. His point? The founders never intended federal judges to have this kind of sweeping power. It's a modern invention with zero constitutional basis. Justice Thomas took it even further in his concurrence. He pointed to Article 3 of the Constitution, arguing that federal courts can only resolve actual disputes between real parties, not make broad policy decisions affecting millions of people who never step foot in a courtroom. The dissenting justices tried countering with civil rights precedents from the 1960s, but the majority essentially said those cases got the procedure wrong, even if the outcomes were right. The Department of Justice held an emergency conference call at 7 this morning. Senior attorneys are reportedly scrambling to figure out how this affects 23 ongoing cases. The White House counsel's office is warning federal agencies that state laws they thought were permanently blocked might suddenly spring back to life, possibly within days. Republican governors are already announcing plans to enforce laws that have been frozen by federal injunctions. Democratic attorneys general are trying to protect their residents from what they see as harmful policies in neighboring states. The political earthquake is just beginning, and it raises a fundamental question. If your constitutional rights change depending on which state you're standing in, are they really rights at all? The litigation landscape just got exponentially more complex and expensive. For 2 decades, advocacy groups have engaged in what lawyers call forum shopping, filing cases in districts with sympathetic judges who would issue nationwide relief. The statistics are staggering. Between 2017 and 2021, 78% of nationwide injunctions came from just 5 districts, representing less than 4% of the American population. The Northern District of California alone issued 19 nationwide injunctions in 4 years. Now that strategy is dead. If you want to block a law nationwide, you'll need to file separate lawsuits in multiple jurisdictions, each with different judges, different arguments, and different appeals if you lose. Major law firms are already warning clients that civil rights litigation, environmental challenges, and constitutional cases could cost 5 to 10 times more than they did last month. Immigration enforcement faces immediate upheaval. ICE currently operates under 14 different injunctions limiting deportation policies, detention standards, and asylum processing. Many of those might now only apply in specific districts. Federal immigration authorities could resume full enforcement in states not covered by those orders, creating a patchwork where immigration law varies dramatically from state to state. Second Amendment cases are equally affected. Gun regulations in 6 states are frozen by preliminary injunctions. If those get narrowed to protect only the named plaintiffs, states could immediately start enforcing firearm restrictions on everyone else. Your Second Amendment rights might literally change when you cross a state border. Healthcare access becomes a maze of geographic restrictions. 11 active cases involve nationwide injunctions preventing enforcement of laws around abortion medication, gender-affirming care, and religious exemptions to insurance mandates. Patients might find certain treatments available in one state, but illegal just miles away in another.
The Supreme Court has just released a potential landmark decision.
Those judges cannot issue what you call universal or some call nationwide injunctions.
Supreme Court severely limiting, if not eliminating, the ability of a district court judge to issue an injunction.
Environmental regulations face similar chaos. The EPA has injunctions blocking clean air rules, water protection standards, and climate regulations that could now be limited to specific geographic areas. A factory might face strict emission standards on one side of a state line, but operate freely on the other. Election law presents perhaps the most urgent challenge. 9 nationwide injunctions currently affect voter ID laws, mail-in ballot procedures, early voting requirements, and voter roll maintenance across 19 states. Under the new framework, the same state law could be enforced in 80% of a state while being blocked in the remaining 20% based purely on where lawsuits were filed. Election administrators need months to prepare, training poll workers, printing ballots, setting up voting locations. The National Association of Secretaries of State expressed serious concerns about operational chaos if injunctions get geographically limited right before major elections. We could see the most legally chaotic election season in modern American history. Corporate America is quietly panicking. Companies operating in multiple states suddenly face navigating 50 different regulatory environments where federal rules might be enforced in some places but not others. The U.S. Chamber of Commerce estimates compliance costs could increase by $47 billion annually as businesses maintain different operational standards in different jurisdictions. Banking regulations are particularly affected. 3 major rules governing cryptocurrency, lending standards, and consumer protection are currently frozen by nationwide injunctions that might soon apply only in specific circuits. Technology companies face uncertainty around content moderation requirements, data privacy rules, and antitrust enforcement that could vary state by state. Healthcare providers and insurance companies are looking at potential chaos around coverage mandates, prescription drug pricing, and telehealth regulations varying by geography. The pharmaceutical industry worries about FDA enforcement actions, with 5 current injunctions blocking drug approval and monitoring requirements that might protect companies only in specific jurisdictions. Employment lawyers are telling corporate clients to prepare for different workplace regulations, wage requirements, and anti-discrimination standards depending on facility location. The uncertainty factor is particularly frustrating. Businesses won't know which injunctions survive under the new standard until lower courts revisit each case individually. Civil rights organizations express deep concern about forcing discrimination victims to fight the same battle in dozens of courtrooms before achieving nationwide protection. The NAACP Legal Defense Fund notes that during the civil rights era, nationwide injunctions were crucial for implementing Brown versus Board of Education, allowing courts to prohibit segregation across entire states rather than just specific school districts. Under the new framework, desegregation might have taken decades longer, requiring separate litigation for each school district. Modern civil rights cases face the same challenge. When states pass allegedly discriminatory laws, should relief be limited to the handful of plaintiffs brave enough to come forward or protect everyone in that class throughout the jurisdiction? Disability rights advocates worry particularly about the Americans with Disabilities Act, which has been enforced largely through broad injunctions requiring systemic changes to government services, public accommodations, and employment practices. Plaintiff-specific relief might not achieve the same systemic change. The fundamental tension remains unresolved. If preventing harm to vulnerable populations requires broad injunctive relief, but the Constitution limits courts to resolving specific disputes between specific parties, which principle should prevail? The Supreme Court's majority opinion focuses purely on Article 3 limitations regardless of sympathetic claims. What's really happening is the Supreme Court reasserting authority over the entire federal judiciary. By issuing this ruling through the emergency docket rather than waiting for full arguments, the court sent an unmistakable message expecting immediate compliance from lower courts. This represents a pattern of the current Supreme Court increasingly using its shadow docket, emergency orders, and summary reversals to control lower court operations. Statistical analysis shows 47 emergency orders modifying or vacating lower court decisions in the past 3 years, compared to just 19 in the previous 3-year period. Emergency orders typically lack full reasoning or extensive analysis, forcing lower courts to comply with broad principles without detailed guidance for specific situations. Several appellate judges privately express frustration, suggesting this creates more uncertainty as they guess at Supreme Court intentions rather than having clear precedential guidance. The practical effect is micromanagement of federal litigation in ways unthinkable 20 years ago. stepping in on emergency basis to overrule district judges, circuit courts, even state Supreme Courts when the current majority believes those courts exceeded authority. This ruling on nationwide injunctions fits perfectly into that pattern. The Supreme Court telling hundreds of federal judges they've been doing their jobs wrong for 2 decades and must change immediately. Whether that represents appropriate appellate oversight or judicial overreach depends on your perspective about federal court system function. The ruling changes everything about how federal power operates in America, and we're just seeing the beginning of the fallout. State sovereignty gains new strength while federal uniformity weakens. Rights and regulations might vary dramatically based on geography. The legal system becomes more complex, more expensive, and potentially more chaotic. Businesses face compliance nightmares. Civil rights advocates worry about protecting vulnerable populations. Election officials scramble to maintain orderly voting processes. Federal agencies recalibrate enforcement strategies. State governments rush to implement previously blocked policies. The Supreme Court has fundamentally altered the balance of power between federal courts and state governments, between nationwide consistency and local variation, between judicial efficiency and constitutional limits. The consequences will ripple through American law and life for years to come. That's it for today, folks. See you in the next video.